Mr. President.
Senator from Utah.
Mr. President, I rise today to discuss and to urge my colleagues to support Amendment number 4448, the Due Process Guarantee Amendment. This amendment addresses a little-known problem that I believe most Americans would be shocked to discover even exists. Under current law, the federal government has proclaimed the power, has arrogated to itself the power to detain indefinitely, without charge or trial, U.S. citizens and lawful permanent residents who are apprehended on American soil. Let that sink in for just a minute. If you're a U.S. citizen or a U.S. green card holder and you're arrested on American soil because you're suspected of supporting a terrorist group or other enemy of the United States, the federal government has claimed the power to detain you indefinitely without formally charging you or without offering you a trial. I'm not talking about American citizens who travel to foreign lands to take up arms against the United States military and are captured on the battlefield. No, I'm talking here about U.S. citizens who are apprehended right here in the United States of America. Under current law, even they can be imprisoned for an unspecified, in fact, unlimited period of time without ever being charged or being given the benefit, the trial, without the benefit of a jury trial to which they are entitled. You don't need to be a defense attorney to recognize what an outrage this is. Arresting U.S. citizens on American soil and then detaining them indefinitely without charge or trial is an obvious deviation from the constitutional right to due process of law. The last time the federal government exercised such power, during the internment of Japanese Americans during World War II, without congressional authorization, Congress responded by passing a law to prevent it from happening again. Of course, such legal protection should not need to be codified into federal statute in the first place, but they did it anyway. Now, the Fifth Amendment of the Constitution states in no uncertain terms that no person shall be deprived of life, liberty, or property without due process of law. But then again, as James Madison reminded us, if men were angels, no government would be necessary. So in the wake of World War II, Congress passed and President Nixon signed the Non-Detention Act of 1971, which states, quote, "No citizen shall be imprisoned or otherwise detained by the United States except pursuant to an act of Congress," close quote. Those last few words are absolutely crucial. Except pursuant to an act of Congress. The Non-Detention Act of 1971 recognized, as I believe most Americans do, that in some cases, in some grave, treacherous, unfortunate cases, indefinite detention of U.S. citizens may, in the eyes of some, be deemed necessary. But the point is that the federal government does not inherently possess the power of indefinite detention. To the extent such power can even be said to exist within our constitutional framework at all, a question that many of us would regard as at least debatable. Certainly, only an act of Congress, such as an authorization for the use of military force or AUMF, or perhaps a declaration of war, can give the federal government that power. But fast forward 40 years, and this important legal protection has eroded. You see, in 2011, 40 years after the passage of the Non-Detention Act of 1971, Congress passed its annual National Defense Authorization Act for fiscal year 2012, the predecessor of the bill that we're considering today. In that version of the NDAA, there was a provision, Section 1021, giving the federal government the power to detain U.S. citizens indefinitely without trial, even those who were apprehended on American soil. Now, it may sound like Section 1021 meets the Act of Congress threshold established by the Non-Detention Act of 1971, but importantly, it does not. It does no such thing. Here's why. The language of Section 1021 merely presumes that the 2001 AUMF gives the federal government the right to detain U.S. citizens indefinitely without having to prove anything, even though an explicit grant of such power appears nowhere at all in the 2001 AUMF. My amendment would resolve this problem. In clear and straightforward language, my amendment clarifies that a general authorization to use military force, a declaration of war, or any similar authority on its own shall not be construed to authorize the imprisonment or detention without charge or trial of a citizen or lawful permanent resident of the United States apprehended in the United States. This means that if Congress believes it's necessary to have the power to indefinitely detain U.S. citizens who are captured in the U.S., then Congress must expressly say so in any authorization it passes. My amendment recognizes that the due process protections of U.S. citizens are far too important to leave up to implied legal contemplation. The 2001 AUMF does not expressly state that the federal government has the power to detain indefinitely U.S. citizens who were apprehended on American soil. It just doesn't say it. You can look at the 2001 AUMF and you will not find that. So if those who believe that it is somehow in the national security interests of the United States for the federal government to have that power, they should file an amendment to the AUMF that says so explicitly. And then we can see that the American people think, and we can find out, just as importantly, what their elected representatives in the House and in the Senate think. Or they can file an entirely new AUMF that provides such authority expressly. Now, Mr. President, this amendment, the one that I'm discussing today, this should not be controversial. In fact, in 2012, just a year after the initial offending provision that I described a moment ago was passed, the Senate passed this amendment with 67 votes, in large part thanks to the tireless efforts of my distinguished colleague, the senior senator from California, Senator Feinstein, who joins me as a co-sponsor of the amendment today. Unfortunately, the Due Process Guarantee Amendment was stripped from that version of the NDAA. The NDAA passed in 2012 for 2013 during the conference process. At the time, some opponents of the amendment were under the impression that it would extend due process protections to U.S. citizens apprehended outside the United States. But that, Mr. President, is undeniably false. The Due Process Guarantee Amendment applies only to U.S. citizens and lawful permanent residents who were apprehended on U.S. soil. It has been 4 years since that misunderstanding prevented Congress from passing this common-sense bipartisan reform. That is more than enough time for this institution to gain clarity on what this amendment does do, and just as importantly, on what this amendment does not do. And so it's time, Mr. President, that we finally pass this amendment, and I urge each of my colleagues to do so.